Hello, my name is Daniel Russell. I am a board member at Go Fish Digital. It's an award-winning digital marketing agency. And today I'm going to be talking about the legal mistakes that you can make on accident, hopefully, when you are using artificial intelligence for work. The examples I'm going to be talking about are mainly from the digital marketing world, but I'd say that honestly these lessons are applicable to just about any industry. Let's get started. One of the most consequential cases for the future of artificial intelligence is this one, Naruto v. Slater. This is Naruto. Naruto is a crested macaque monkey, and he took this picture. It's the famous monkey selfie. You may have seen it before. He's quite the photogenic guy. This is Slater. Slater is a photographer who purposely set up his camera equipment in hopes that the monkeys would take some pictures with it. And he succeeded in getting that great picture of Naruto. He won a lot of awards for that picture, was able to sell a lot of copies. I think it was, kind of his opus. It was his probably most impressive picture to date. But then PETA heard about the picture and said, wait a minute, Mr. Slater, you didn't take that picture, Naruto did. So all those accolades, the money that you're making from it, those should all go to Naruto. So PETA brought a lawsuit against Slater. Now the court took a look at this and they said, for one, hey, copyright holders actually have to be human. And Slater is a human, but Naruto did take the picture and he's a monkey. So the surprising holding here is that actually no one owns the copyright to that famous monkey selfie. It is actually in the public domain, if you can believe it. Pretty wild. Now, I am going to be talking about a couple other examples just like that one where you can kind of start to see the legal implications for artificial intelligence, the legal landmines, as it were, that you could potentially step on if we're not careful. I am a marketer. I've been in digital marketing and running a business for the last decade and a half or so. However, I'm also an attorney. I went to the George Mason University School of Law, where I was the editor-in-chief of the Journal of Law, Economics, and Policy. After I graduated, they rebranded to the Antonin Scalia School of Law, which becomes a problem because with these long university names, what do? You shorten them into acronyms. And when you do that with Antonin Scalia School of Law, you run into some problems. So anyway, I didn't know how this passed, the quality checks, but us alumni were saying, what in the world? We can't put that on our resume. And the school said, okay, sorry, use the first letter of every word. And we said, honestly, that might be worse. That might actually be worse. So they eventually said, all right, we're going to switch the name around, but for my money, I just call it Mason Law. So I graduated from Mason Law, passed the bar in Maryland. I did not really practice that actively, but being a lawyer in marketing, especially highly engaged in artificial intelligence for the last couple of years, it's put me in kind of a unique position to understand how all of this comes together. Now, I am an attorney, and as any good attorney has, I've got a proviso for anybody watching, which is, yes, I am a lawyer, but I am not your lawyer, all right? This is not legal advice. This is not meant to create an attorney-client relationship in any way, shape, or form. Just had to get that out there. So as I started playing around with artificial intelligence, really getting in with the early versions of ChatGPT, I had a lot of questions about the legality of all of this. I had questions about who owns copyrights to images that you create? Are you violating your NDAs if you upload data to ChatGPT? What can you do if Google Gemini is copying your content without a citation? Is OpenAI a nonprofit or what? Are we all even going to have jobs in 5 years? I'm sure you've probably had some of those questions too. But let's talk about those legal ones specifically. Here's what we'll talk about. Can you use AI tools on sensitive information? Who owns AI-created content? There's a couple pieces there. Is AI using your content without permission? And then lastly, how can you influence the future? Let's start with number one here. This mainly revolves around an area called data privacy. Data privacy laws vary dramatically country to country. If you want to know more about your specific data privacy situation, I recommend talking to an expert. However, there is one document that seems to cross most countries, most professions, and that is non-disclosure agreements, NDAs. And if you've had questions about what can and can't be shared under your NDA, you're not alone. The other tricky part is that you can get pulled into NDAs in more than one way. For example, I have two types of NDAs. I have an NDA with me and my employer, Go Fish Digital, and it basically just says that I will not disclose confidential information of Go Fish. But then also Go Fish Digital has as the employer, has NDAs with its clients saying that it will not disclose client confidential information, and that includes its employees, which includes me. So there's a few ways that you can get pulled in. Other people have had lots of questions about this too. If you look on the internet, you can see on Reddit, on Quora, other places, people asking about it, raising concerns about privacy issues. You've got this guy, and luckily, he's anonymous there, but he says if I let ChatGPT proofread a top secret document, period, will ChatGPT then be trained on the content of that document? And the short answer is, depending on the context and the circumstance, what version you're using, et cetera, yeah, it probably could be trained on the content of that document. So because everyone's situations are so dramatically different, NDAs vary quite widely, I've got a rule of thumb to follow. And that is, if you're not sure, don't upload data. Just don't do it. Don't upload data to these AI platforms unless you have express permission from the data owner, from the confidential information owner. It's honestly probably not worth it. So keys from this section, and I'll have some keys for each of these sections to wrap things up. Don't violate your private agreements by using artificial intelligence, and don't share sensitive information with artificial intelligence unless you're given express permission. All right. Next, who owns AI-created content? This area of law revolves around ownership, more specifically copyright, which is literally the right to distribute and sell copies of a work. Now, to have a copyright, a lot of people think that you have to go through some super complicated process, get it registered, etc. Those things can help, but actually all you really need is these three things. The work needs to be original, can't be a copy, can't be stolen from somewhere. It needs to be fixed to a tangible medium, and that includes the internet. And it needs to have human authorship, as we learned from Naruto. Let's dive in on that human authorship element a little bit more. In this case, Thaler v. Perlmutter, Professor Thaler, this is him, created some AI art. And you can tell this art was created a few years back because it's all staticky. That comes from the way that this art is actually compiled. It's basically trying to de-static and get to the image that way. But he created this work of art, obviously a train track here, and he submitted it to the US Copyright Office. Again, not a mandatory step, but he wanted to be extra legitimate here. The United States Copyright Office responded via Director Perlmutter, this is her, and said, sorry, no copyright because this doesn't have human authorship. It was created by AI. So Professor Thaler sued, and that holding hasn't been released as of the recording of this video. But the courts might very likely say, hey, there's not quite enough for us to judge on, and pass it on to Congress and ask them to legislate more before people can start ruling on cases like these. But it does point out something very important, which is that AI is very clearly a tool. But is it like a camera? Is it like Photoshop? Or is it something else entirely? That camera question is interesting because another time when there was this big technological leap and it caused the copyright world to be turned upside down was the invention of the camera. In the late 1800s, in this case, Burrough-Giles lithographic v. Cerrone. Cerrone was a photographer and took this picture of Oscar Wilde. Pretty great photograph. Burrough-Giles lithographic saw the photograph and said, thank you, we are going to sell it, we are going to distribute it, we're going to package it up, put it out there, all without paying for licensing or giving you any money or asking for permission, because in the Constitution it says that people have a right to their writings. And you did not draw this, you didn't paint it, you just pushed a button on a camera. So we don't think that you have a copyright to it. So they went to court, and what the court found was, all right, correct, Cerrone did not draw the picture, he only pushed a button. However, he had to make creative choices over lighting, composition, subject matter, etc. And so we are going to expand writings from the Constitution to include all ideas in the mind of the author that are given visible expression. Now, this definition is important because to me, it seems like AI art should be captured under this and should be copyrightable, because a prompt into an AI is an idea in my mind, right? So I've got this idea, I put it out in a prompt, and then that prompt is given visible expression by the AI. So to me, in theory, it should be pretty darn similar to this camera case. To test that, in comes Chris Castanova. This is Chris. Chris is cool. I'm going to explain why Chris is cool. I like Chris a lot. Chris created this comic book using Midjourney. And if you look at it, that person in the comic book might look a little bit familiar to you. If you take a guess, you're probably right, because this is one of the prompts. Sci-fi scene, future empty New York, Zendaya leaving gates of Central Park. So Chris put prompts like this into Midjourney, got the images out, made some very slight alterations using Photoshop. You can see the difference in the lips there. And then submitted the comic book, once again, to the Copyright Office. Now, unlike the previous case, Chris got a copyright registration. Pretty cool. However, a little while later, Chris got this letter from the US Copyright Office, and basically it said, just kidding, we made a mistake. More specifically, it said, we conclude that Ms. Castanova is the author of the work's text, as well as the selection, coordination, and arrangement of the work's written and visual elements. That authorship is protected by copyright. However, as discussed below, the images in the work that were generated by the Midjourney technology are not the product of human authorship. There's that human authorship again. They went on to say, Midjourney users lack sufficient control over generated images. They said this is not like a camera. With a camera, you know what the picture is going to look like before you push the button. So you can actually make those creative choices. But AI is a black box. They said specific output of AI tools cannot be predicted. So they said, so in this case, it just doesn't seem creative enough. It doesn't seem like you're really the author here. Now, one of the main big takeaways here is that images don't get copyright. A lot like that picture of Naruto, which is in the public domain, images created by these AI tools would very likely be ruled to be in the public domain as well, because they don't have that human authorship, so they don't technically have an owner or an originator. One important point from that letter, however, is the arrangement of the images and text together into the comic book did get copyright protection. And that's important for us in digital marketing and in other fields as well. Now, Chris, I mentioned, is cool. And one of the reasons Chris is cool is because Chris saw this feedback and said, all right, you think I lack sufficient control over the images. You think I can't predict what it's going to look like. Well, now I'm going to draw. I'm going to draw an outline, because now I have some control over it. I know what it's going to look like. And then I'm going to upload that drawing into, I think in this case, Stable Diffusion, and then ask Stable Diffusion to flesh it out. And now what, Copyright Office? and we'll see. We'll see what the Copyright Office says about stuff like this. But Chris is pushing the envelope here. Chris is putting the Copyright Office in kind of a tight spot, trying to find the line, which I really appreciate. All right, keys from this section. No one owns the copyright to AI-originated content. This is especially important if you have used AI for IP-critical tasks. If your logo is AI created, right? If other really key imagery or text is AI created and it stands on its own, that might be public domain. You might not have any legal protection there. However, organizing AI-generated content into web pages, PDFs, etc., can grant copyright protection, and that is a bit of a relief. All right, next up. Is AI using your content without permission? The legal terms you'll hear thrown around and non-legal terms are permission, licensing, and a trailblazing case in this particular area is Field v. Google. way back in 2006. Field created a website, and Google created a cached version of its website, which, if you're familiar with how Google works, this is very standard practice now. But back then, it was a little bit newer. And Field said, wait a minute, Google, you just created a cached version of my website without my permission, etc. That is violating my copyright. I've got a copyright on that website, and you just created an illegal copy. So it went to court, and the court said, actually, Google's use of cached content is not copyright infringement because, for one, you could have blocked the Google bot that came through and created the cache and crawled your content. But you didn't, and so you gave implied permission by not blocking the bot. Also, the caching benefits the public because Google is providing this search service. And also, you're probably not even harmed, Mr. Field, because you actually will probably be found by more people now that you are listed in Google. So we don't even see a harm here. And that harm element is really important. In fact, it literally just a few weeks ago helped OpenAI win a case against some news outlets. They had sued OpenAI saying, you are using our news articles and training on our content, our copyrighted content, without permission. And the court said, among many other things, that we can't really find the harm here. You had these publicly available. Again, you didn't block these the AI tools bots from crawling your content and scraping it. So we don't really see a harm. And that's going to continue to be, I think, a key theme into whether or not these AI tools can use our publicly available data to train. Because the short answer is they probably will be able to do that. And that training data is what's at the crux here. And if you are unfamiliar with training data, artificial intelligence, especially these LLMs, require just massive amounts of data, terabytes of data, in order to get up to speed and to get trained. And you probably have unwittingly participated in labeling some of this training data. If you've ever filled out CAPTCHA tests like this, you are literally labeling images for image recognition, self-driving cars, other different types of AI platforms. Even things like this app. If you ever use the Google Arts and Culture app, more people are familiar with this feature that you could create, take a selfie and then find your art selfie. And it was really good at it. Even if you were wearing a hat, even if you were making a face, this poor guy, he got compared to this real painting. That's a real painting in the Uffizi Gallery. This lady who was compared to a Habsburg, and she said, this is a bad app. And she was onto something, I think even more than she knew, because hidden in the terms of service for this app was a little proviso in there that said that Google could use these selfies to train its facial recognition AI amongst other machine learning platforms. So it's very likely that you have even participated in this. Maybe you didn't know it, but you were technically willingly giving these platforms training data. Now, this training data issue gets at the originality aspect of copyright requirements, because we've seen that courts say it's probably okay that they're using your publicly available data to train. But what happens when what comes out of the AI platform looks a lot like that training data? And that was explored, one, through this legal concept of substantial similarity, which is basically straightforward. If whatever is created is substantially similar to something that already exists, then it's probably not original enough to get a copyright. It's probably too much of a copy. In Anderson v. Stability.ai, Anderson and a bunch of other artists, this is some of their artwork, brought a lawsuit against Stability.ai. Stability.ai is the purveyor of Stable Diffusion, a image generation artificial intelligence. And what they argued was that all of this art was used by Stable Diffusion to train, and now Stable Diffusion is spitting out images that look a whole lot like their art. You can see an example here. Gerald Brome, apologies if I'm mispronouncing that, but Gerald's original art is in the top left. And then if you ask Stable Diffusion for, I don't know the exact prompt, but like a witch lady, red dress, white hair, it creates something that looks a whole lot like the original, Some might say substantially similar. So these artists were saying, okay, you trained on our stuff, and now it's creating images that look exactly like the training art. So there's got to be some copyright violation there. Additionally, the artists argued that Stable Diffusion was violating their name, image, likeness rights because it was allowing people to create art in the style of them, right? Now, the case, like others, is still ongoing, but so far, the court has said that the copyright infringements can claim because of that substantial similarity. Those images look substantially similar to each other. The name, image, likeness claims cannot, mainly because they said you guys don't really have a brand name to copy per se. Like if this was the Picasso GPT, or something like that, then you might have a case because that's a known person with a known brand, a known name, with known art style, etc. But as we've discussed previously, using the publicly available data to train, once again, is probably safe. So to summarize this part, we can say that AI is probably allowed to train on your public content and data. That is probably going to stay okay. There's not a lot you can do about that except block the AI bots from crawling your content, and I would not recommend that. The short of it is just that the future is going to be in artificial intelligence, and if you completely block yourself off from it, you're much less likely to show up in future Perplexity searches, future search GPT searches. You're just much less likely to be future-proof. However, if they're blatantly ripping you off or inducing other people to copy you, you might have a case. Now that name, image, likeness stuff comes from the right of publicity, which basically just says that you have a right to your representation, that you yourself can be a brand. And as for an example of how you can actually get in trouble for that, I've got one to show you. Now this is different from the art. This is an audio example, but take a listen to this audio clip and then let me know who you think it sounds like.
I came in with my ex like Selena, the flex, bumping Justin Bieber, the fever and left. She know what she need, or she blessed, giving.
It's a great song. If you haven't heard it before, you can still find it on YouTube. That's where I had to find it. But if it didn't jump straight to your mind, you can see it somewhere on this YouTube clip that it's supposed to sound like Drake. It sounds exactly like Drake, but it's not. It was created using artificial intelligence, which is pretty wild. The difference here is that unlike those artists, people know who Drake is. Drake has a very distinct cadence. His voice is unique. He's one of the top streamed artists of all time. So this person got in trouble really quick. I think they put it up on Spotify, and it got close to 1 million plays before they got contacted and had to immediately take it down. But like I said, you can still find it some places like YouTube. So keys here is that you can still get in trouble for using AIs to duplicate other people's copyrights and name, image, likeness in that Drake case. And you can't rely on the AI tool safeguards to keep your work legal. You might think like, oh, they won't let me copy other stuff. And if you've tried to do that with, say, Dall.e, OpenAI's image creation, sometimes if you do ask to create known copyrighted intellectual property, it will block you from doing that. Even if you ask the advanced voice mode in ChatGPT to talk to you like a famous person, like Arnold Schwarzenegger or something like that, it can block you. But you can so easily get around that, and there's just lots of other ways to get in trouble that they won't be blocking. And they honestly don't have that big of a responsibility to us as the users. There's some, but not much. So we have to create our own guardrails. And to help us in this effort, I've got an activity to run through with everybody watching, which is unpopular, unethical, illegal. Okay, 3 choices. I'm going to give you some scenarios, and then you just think to yourself whether that would be unpopular, unethical, illegal. None of them are going to be like super popular, all right? So first one, an AI model trains on your website content without permission is the implication here. What do you think that is? Unpopular, unethical, illegal? It's probably unpopular. I don't see this changing. It's been this way for Google, for Yahoo, Bing, other search engines, and other big aggregators on the internet. It's probably going to be just fine and stay just fine for these AI platforms to train on your public website content. You might not love it. That's the unpopular part. But it's probably fine. Perplexity.ai answers a search with your content, but then doesn't cite you. Unpopular, unethical, illegal. It's probably unethical. I think this goes a step beyond unpopular because we should cite our sources, but it's possible based off of past search engines that they wouldn't necessarily get in legal trouble for that, though I really wish they would cite their sources. Last one, you create an AI Michael Jackson to sing about your brand. It's probably pretty obvious that's illegal. Don't do that. It sounds like a lot of fun. Maybe you could get away with doing it, just for yourself on your own computer, but you definitely couldn't put it out there in the world. That's pretty clear copyright, right of publicity, name, image, likeness violation. All right. One quick case study to help tie all of this together. So about 8 years ago, I was interviewed, and I've got this clip here that I want you to watch, and then I'll ask you some questions about it.
E da allora abbiamo goduto di una crescita davvero ottima. Abbiamo quasi raddoppiato praticamente ogni anno e gran parte di ciò è dovuto al nostro impegno nel trovare ciò che verrà dopo e essere un po' all'avanguardia. Cose come Reddit sono...
All right. I really wish I spoke Italian, especially like that. That's good. That's good Italian. If any of you are Italian speakers, from what I've heard, that's very good Italian. I don't speak a lick of Italian, not at all. But what I did is I took this clip of this interview I did, and before the interview, I signed a release form that said that the interviewer could use this footage, could use my name, image, likeness, right, and that they owned the copyright to whatever video came out of the interview. But I took a snippet of this video and then ran it through an AI platform, HeyGen, you can see in the bottom corner there, and had them use my voice, sample my voice, to translate it into Italian. You could hear that it sounded just like me. And then to change the movement of my lips in the video to match the Italian. So after all that, who do you think owns the copyright to this Italian version? It's a little complicated. It's very likely that when I uploaded the clip to HeyGen, in the terms of service, I gave them permission to use it, just like I gave the original interviewer permission to use it. However, I don't actually necessarily know that it was my permission to give. It's very likely that this is still substantially similar. It has not been transformed enough to be something new that someone else can take the copyright for. So it still probably belongs to the original interviewer. The reason I show this is, one, to show the power of artificial intelligence, but also because you got to be careful and make sure you know where your content is sourced from and who the original owner is, and whether or not you can actually continue to use that. All right. Let's recap these different keys. Don't violate your private agreements by using AI. Don't share sensitive information with AI unless given express permission. No one owns the copyright to AI-originated content for now. Organizing AI-generated content to web pages, PDFs, etc. can grant copyright protection. AIs can train on your public content, and there's not much you can do about it except block the bots. Don't prompt AIs to copy other people's work or name, image, likeness. And to summarize, lawmakers are just not moving fast enough to give courts and creators what they need to navigate all of this, which takes us into this last point of how can you influence the future. As of the time of preparing this deck, this is what I thought of in terms of what we all can do to participate. There are 150 AI bills pending in Congress. Again, this is at the time of preparing this deck. And there are 762 AI policy measures pending in different states. So at the moment, it looks like there's going to be maybe some slow stuff coming from Congress, and then this patchwork of policy measures in different states. It's honestly going to be really messy. And you can influence it. If you contact your politicians, you can use these links to find your senator, to find your House representative. You can let them know how you feel. Because these cases and laws that we've talked about today have defined the past. But you can define this future. You can be critically involved here, just like we talked about the camera today and how much that changed things for the past. People in the future will be talking about you and how we are using artificial intelligence right now. Thank you very much. Feel free to contact me. Email, LinkedIn, you can find me on Twitter, X. I'd love to chat.